YouTube channel, Changing Lives.
I'm sad. You know, I'm so sad. I'm so sad. I don't know if I'm sad or I'm happy, because this is the 13th episode, and we are about, you understand, ending. So today is the end of this season, season 4. So I don't know if I should be happy or I should be sad. I'm happy because Charlie, my breath, as I say, my breath. But I'm sad also because you'll miss me and I'll miss you. And I'm a what? So welcome to the Law Chambers, where legal matters are discussed from a Christian perspective. The name is Anita Delight. And hey, season 13 already. Hey. All right, so this season, you've been with us through it, right? If you've not been with us through it, don't worry. Just go to Facebook, look for the Law Chambers, and just watch all the previous videos, okay, and update yourself. So this particular season, we've been discussing the worker and the employer-employee relationship. That's what we've been doing so far. And we've discussed before you are contracted, before you are employed, the types of employment we have. We've discussed about the relationship, the kind of contract that exists between the employer and the employee. We've discussed when issues arise, how the TUC came here. We had the Employers Union Association come in here. The Ghana Employees Association, we had them come in here. We've also had the Labour Department under the Ministry of Employment come in here. We've had so many people come in here. I can go on and on, but you get the drift. We've had all the important stakeholders in the employer-employee relationship. We've had them here. We've had the lawyers. We have the human resource aspect here. And today is no different. We have very important people here. We have a lawyer here, lawyers actually, and we have a human resource director herself from the University of Ghana here. So today we are just ending the season. I don't know if it's on a good note, because we're going to talk about termination, and then we're going to talk about grievance resolution. So when you're talking about the relationship is not a permanent one. You see, the employer-employee relationship, it can be permanent, but it is not permanent. Meaning that the employer can let you go, or the business can wind up, or you, the employee. That's what we always do. We go up, 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 up. You understand? You can leave the employment relationship. So let's see how this is done and how it's supposed to be done aright, legally. So that when you are let go, you ask yourself, was it done legally? Was it done the right way? If it was done the right way, that's fine. If not, you will look at the repercussions thereof. When we are done with that, we also discuss about the grievance resolution proceedings. You see, sometimes there are issues in the company. How do we resolve it? You understand? We'll be discussing all that. And so this season has been African print all the way. You've done well, right? This season was African wear. And believe you me, I have two beautiful, wonderful ladies who have been so helpful with my African print throughout the season. And I have Samuela. She has a less fashion mall. If you want fabrics, African fabrics, good African fabrics at affordable prices, call Ella on 0243018508. And then if you want someone to sew it for you, the perfect person to sew for you is Rose. That's Mamel's Creation. Call her on 0541809393. Just mention my name, or you just say Anita Delight recommended you, and right there you get a discount. Right there you get a discount. So please patronize them so that we also get more sponsors. If you are out there, you want to sponsor the show, you are very much welcome. Call us on 0559-680066. And if you're out there, you have any questions, any contributions, the same number, 0559-680066. Just call us or send your message, your WhatsApp. And you can also social media handles anywhere. Just send the message there, and then we will read it for you. So as I said, today we are looking at the employment. We are looking at employment matters, the contract termination and grievance resolution. And I have with me two very strong lawyers, and I'll have Dr. Yvonne Ayakai Lamte. She'll be joining us online, and we'll be having this discussion. So let me start with lawyer Peter Ni Ajeblebo. Peter is an associate lawyer at Swift Law Legal Advisory. That's a full practice law firm located at Jowolo. His areas of expertise are AGR, corporate and commercial law, trademark, registration, labor law, land legislation, banking and insurance, surrogacy, adoption and matrimonial matters. Surrogacy is a new area. I really asked him a little bit about it. He has a background in the fields of financial accounting and auditing. So he has a master's degree in finance and accounting and finance from UPSA. He also has a degree in accounting from the same institution and an HND from Accra Poly. Peter has worked with the judicial service, and when he was there, that's when he was inspired to be a lawyer. He doubles as a private tutor, a mentor, and a legal influencer. This is the first time I'm hearing that. Legal influencer. I think I should start using that title myself. With an outstanding reputation for preparing law students for the Ghana School of Law. So if you are going to write the Ghana School of Law entrance exams, he's a right person to yes. If you also are in school, you understand you're in school, part 1, part 2, you're having difficulties, he's the right person to talk to. And he has authored 2 books, Legal Release for Professional Law Students, and that's a question and answer book on conveyancing and drafting. If you're in law school, you know what I'm talking about. And he's also has a revision case for entrance exams candidates, first of its kind. He's also looking at a new book, which is to guide interns and pupils, hoping to be launched this month. So this month, he'll be launching his book. So if you're a pupil, or you're an intern in a law firm, or you want to be one, this is a book you have to look out for. He writes, he loves to chat and spend time with his fellow colleagues. He loves music as well. Hey!
Interesting,
Peter,
yes.
Your friends are lawyers, me and Annie.
Love music.
Not really. So you say you like
I wish
to
to see others dancing as well.
You dance?
No, I want to see others dancing. I don't know how to dance well,
so you usually
I want to sit in my seat and watch people dancing and listen to music.
I love that. You say when you are sitting, you be doing this and I sing I love that bit. I love that bit. All right. So my second guest is lawyer Dame Awuno Williams. She's a private legal practitioner and currently a legal associate. She's worked with the legal department of an oil marketing company in Ghana, where she provided company secretarial and other legal support services that ensure that the company managed its legal risks and compliance with the legislations. Prior to her legal career, she was a senior administrator at the Department of Communication Studies in Ghana for several years. Her area of expertise are corporate and commercial labor and land dispute resolution. Dame, you're welcome.
Thank you.
I remember the first time when I was there to do my master communication, University of Ghana Communications. I saw you, I'm like, this lady is pretty. And then you opened your mouth, I'm like, damn, she's very eloquent. You were no nonsense, eh?
Anita, are you sure?
Hey!
I don't believe
Should I call? Oh, I'll call ya.
I don't believe
I have witnesses. So just 2 witnesses.
Unfortunately, a lot of the witnesses will attest that their first impression was not right.
That what, you were pretty and then you were very eloquent?
That I was not a no-nonsense person.
No, you are not
I
a
come
no-nonsense
off
person.
as such, but I'm not.
You said, no, you know, I come off as such, but all right, so our last guest who is joining us online, thank you so much, Doc, for joining us. Dr. Yvonne Ayakai. Doctor is the director of the Human Resource and Organizational Development Directorate at the University of Ghana, Legon. She has been a senior lecturer with the Department of Organization and Human Resource Management at the University of Ghana Business School. She holds a PhD in Business Studies, a Master of Philosophy in Human Resource Management, and a Bachelor of Science in Human Resource Management from the University of Ghana. Doug is a member of the Chartered Institute of Human Resource Management Practitioners Ghana and affiliated to the Chartered Institute of Personal Development. She is a listed mediator and arbitrator with the National Labour Commission. She held the office of the Human Resource Specialist for Compassion International Ghana. She was also the Human Resource Executive for the Unicorn Group. Dr. was also an HR coordinator for Research Select, where she was a Human Resource Management consultant for years. She has practiced and lectured HRM for over 10 years and supported both national and international organizations to successfully develop and implement HR management systems and interventions. She has consulted for private and public sector organizations to develop and implement human resource management strategies, systems, policies, and procedures. She has trained management and employees in several organizations in different sectors in HR, organizational behavior and its management, and in general management. She specializes in employment relations with particular interest in women in leadership and church evangelism. Dog, you're welcome.
Thank you.
Thank you so much, Dog. I apologize. I apologize for the little. My apologies, Dog.
Okay.
When I saw that your particular interest is women in leadership and church evangelism, I'm like, hey, are you a pastoress?
It is my work at church, and I enjoy doing it.
Oh, that's beautiful. That's beautiful. Thank you so much, Doc. Thank you so much
You're
for
welcome.
joining us. Audience, please let's zoom in. So, let's look at termination of employment when it comes to the employer-employee relationship. When you talk about termination, what is it?
Okay, so before I start, let me extend my warm greetings to your listeners. So we are talking about a relationship between an employer and employee coming to an end.
Okay.
Yes, and the effect of that is that any legal obligations between both parties will consequently also come to an end or cease. Yes, that is it.
Okay. And when we talk about the relationship ending, how is it supposed to end? How does it end?
So as I say, employer-employee relationship, it means you are no more working for the employer, and the employer is also no more paying you. So that relationship comes to an end. You don't provide any service to the employer, and the employer also does not pay you.
And so what are some of the ways that these two can part ways? Doc, please if you could help us out. The termination and how the ways that this relationship can be terminated.
Right. So there are a number of ways in which the relationship can be terminated. So, for instance, if someone dies, obviously the living and the dead do not have any business together in this regard. So naturally, the employment relationship gets terminated. Or and the employee could decide that I cannot have it, or I have other interests, and based on that, I want to move out. So then the employment relationship can be terminated. There are the other forms where the termination could be triggered by breach. Okay, so for instance, there are terms of employment. The employer lays out conditions that cannot be tolerated within the institution. So when you flout and the consequence is termination, then it means that in that regard, the employer could dismiss you. So there are different reasons why forms that termination could occur.
Thank you so much, Doc.
Okay,
Yes,
to add up
Peter.
to what Doc has just said, you could also be dismissed summarily. And when we say dismissal summary, by summary dismissal, we are talking about proven misconduct. I've seen serious misconduct by the employee, and based on that, you could also be dismissed from the employment.
Okay. So the one is the mutual agreement. That's okay. Let's go our separate ways. Another one is
Proven misconduct.
proven misconduct. Another one is, as Doc said, when you die. Obviously, when you die, you can't replace it.
It's a contract in persona, so it's between persons. So.
Exactly. So looking at all these, let's say, for example, I want to leave my employment today. I'm no more interested in working where I'm working, and I want to leave. How do I go about it?
The first point source to look out for is your contract of employment.
Okay.
A typical contract of employment would state the nature of termination or the mode in which you can terminate your employment as an employee. Okay. Same as the employer. Okay. They'll typically state the mode. It may also go ahead, the organization may also go ahead to have a collective agreement which would stipulate specifically procedure to go through in terminating employment. And so that's your first source document should be your contract of employment.
Okay, so when I go there and there's really nothing there, or we don't have such an agreement, what happens?
Okay, we also have the labor law that governs relationship between employers and employees.
Okay.
This is labor relations. So we have the Labor Act 2003, Act 651. Okay. Okay, so it also provides that you can also give notice to your employer, and the employee can also do same.
How many? We are looking at 1 month notice?
Conventionally, we are looking at 3 months notice.
Okay.
So you make your employer prepared that you want to leave his employment. And same, the employee could also do the same. The employer also could also do the same, that he doesn't want to have any business with you.
Okay. So if I give the notice, or I don't want to give the notice, I've been employed, and hey, I want to leave, sharp. I say I can't leave until the end of the period. If not, what are some of the things you have to be careful?
The alternative is to, you as an employee, if you want to leave, you would either give the notice period, or you forfeit your salary in placement of the notice period, same as the employer. So if it's to take an immediate effect, if the dismissal or the termination take an immediate effect, then the employer is supposed to pay you that month the duration of the notice period in lieu of the notice. Yes.
Okay. So let's say, for example, so what we are trying to say is that when you're about leaving the employment relationship, and then you don't give that time, so sometimes it's 1 month, we have the 3 months, some institutions have 6 months. I don't know why they do that. Yes, I saw one and I was shocked. 6 months. So if that is the case, depending on what's on your contract, if you want to leave, it means you have to pay the institution that amount. So either you give them the time or you pay the institution that amount. But Doc, if I want to leave the institution, what are some of the benefits or the payments I should look out for from the employer?
Right. So when you are leaving, you are expected to live on a clean sheet. So if you, as an employee, on a loan, typically loan advance, and you have the company guarantee for you, or if on the other hand, if the employer owes you some delayed pay that is due, on both sides, you are supposed to settle your bill, your debt, and then on the date that you indicated that the employment would end. And in that regard, if there is any equipment that has been provided by the employer, that too should be handed over before you leave.
Okay, Doc. So, yes, Peter, you
I
wanted
want
to
to
ask
add
something?
up. Okay, so you were asking about some payments that you can receive from the employer if your contract is being terminated. Okay, so from your contract documents or a collective bargaining agreement that you may have with your employer, there could be a package. Some organizations will say if you work with us for 5 years, we have a severance package for you. And this is the amount. If you work for 10 years, if you work for 20, so each number of years that you work with them has a package which you are entitled to at the time of your leaving there, exiting from the company.
So what about your leave? What about your sometimes? Okay, we'll talk about when it's winding up. But what about your leave? Let's say, for example, someone asked a question, which was an interesting question. That let's say I have 21 days within the year, and in half of the year, in June, ending of June, I want to leave. How does my leave come in here? Am I still entitled to maybe half of my leave, or do I just? How does it work?
I think it all boils down to the conditions of service and your contract of employment. If those provisions are specifically stated in there, it states how you are supposed to go about termination, your benefits that are accrued, what you are entitled to, then it's very easy for you to know what you are entitled to. However, if there's nothing like that, then depending on the nature of the job, you can look at the Labor Act to demand those benefits, depending on the nature of your job. Exactly. So it's safer if you have your conditions of service, your HR policy, a contract of employment that specifically states that. But if not, it's not too straitjacketed. You have to either inquire from the HR or look to your Act 651 to find out how to go about it.
But the person is a lawyer, so the person is asking you, how do I go about it?
So that's the procedure. If you are looking at your conditions of service, there should definitely be something in there regarding termination. You don't have any. There's none in the contract of employment either. Then you go to the Act 651.
Okay, and Act 651 is telling us that you will be pro rata, right?
Yes, the pro rata basis.
Okay, so now let's look at, so all we've discussed so far is termination when it is fair, right? So now let's look at unfair termination, Doc. What is unfair termination and what amounts to unfair termination, Doc? Okay, we want to take it. Peter.
So we have termination by notice, and that's we refer to that as fair termination. If it's unfair, then it means you have been dismissed without any notice. Okay, so that's what I want to say for now.
Well, the Act 651 also specifies what exactly is unfair termination and provides certain grounds. So, for instance, if your employment is terminated on grounds of your gender, say you are a female, so a certain job that is available is no longer fit for you, deemed fit for you, and so your employment has been terminated. Or by virtue of your religious, political affiliation, your contract is terminated. There are also instances where, as a female, your contract is terminated on grounds of pregnancy or being absent due to your maternity leave period.
And it happens a lot in most institutions.
Yes, it does.
The minute a woman is pregnant and she goes on those maternity leaves, they tell you not to come back.
Yes.
And a lot of the women just take it to stride. Like, okay, and a friend called me, my employer someone back to me, I'm saying,
but you see,
how does that happen?
In such instances, it's only when it's been specifically written, like it's expressly stated that this is the ground for termination. But if it's verbal, it will be difficult for you to take that up. But we can
infer. So let's say, for example, I'm pregnant and I deliver and I go for my 3 months maternity leave. And then all of a sudden, you send me a message that my contract has been terminated, or you terminate my contract. You know that the law usually will tell you that there's no need to give a reason for termination. But now the courts are saying that you should give us a reason for termination. And so even if you terminate the appointment, you go like, you did this, that, because that's a good reason. But if you terminate the relationship, no reason, but I just went to deliver, and I'm having my 3 months maternity leave, we can infer that it's because of my maternity leave. That's why you've terminated my appointment.
Well, in such instances, as I said, if you are taking it up in court, it will be very difficult to prove if it's not expressly stated. If
Actually, this case will be one. Yes, it should be easy to win.
Especially as they follow, say they are going according to the notice of termination, they give you the required notice period or salary in lieu of notice. They have fulfilled the terms of the contract.
But yes, that's why.
To that extent, it's not unfair.
Previously, they'll tell you not to give a reason. So all I have to say is I've terminated your the appointment. So come and pick your 1 month check from the finance. Now they're saying like give reasons, because when you don't give a good reason for termination, it is then imputed that it was unfair termination, and so now you, the employer, have to come and prove that it was fair termination. And I think it's because we have a lot of women out there who go deliver and they come back, and their first child they go and come back and they tell you, yeah, so the woman is also, so the minute she gets pregnant, she knows she's about to lose her job, which shouldn't be the case. So please,
it's because most of employees do not know, employers do not know the law. They are not supposed.
Some do not care.
Oh, so we need to bring this to the attention that this act is bad.
I think that's why we are here.
This act is bad. So you need a medical certificate as a lady when you go to the hospital. Those things need to be. You need a doctor to give you a medical certificate to prove that you came to deliver, and you could also be terminated unfairly based on injury.
Yeah.
And for that matter, too, you also need a medical certificate to prove. Yeah. Because sometimes you come back and they say, no, you don't have space anymore. So when you have those things to prove and they still want to take you off your job, you can give it to your lawyer to take it up. So the name of the game
is evidence, right?
Yes.
And that's what I've been saying all along. The name of the game is evidence.
I
remember there was a gentleman who got injured while working, and then 2 months later they told him that they are laying people off. So when he told me, I called the HR and said, are you restructuring? Because if you are restructuring, that's a whole different ball game, and we can have a discussion about that. He said, no, we are laying people off. And I'm saying, so if you are laying people off, there's a procedure. And that's another thing. Your employer can one day say that we are not making a lot of money, so we are restructuring, so we are laying you off. That's a form of termination. But that termination comes with a lot of benefits, you understand? So if you are terminating such a person's appointment, you have to go through the labor officer, there's a whole process, and a lot of benefits for the employee. And so shine your eyes, you understand? We are not saying, as I said, the relationship is not 100% that no one will leave. But when you are leaving, you should leave because you are leaving on the right reasons. You understand? So now let's talk a little bit about termination. Let's talk about winding up. When you are winding up and then you have to lay people off, or you are restructuring and you have to lay people off.
With that would be known as redundancy in our law, and with that there are specific procedure to follow. As you earlier said, you would have to notify the chief labor officer. You have to officially notify the chief of labor officer, and then there are actually preconditions to satisfy that when you are notifying that. So usually it's either the company is being closed down, is being merged, or being amalgamated with another company, or in instances where there is a restructuring or reorganization, as you said, you have to notify the chief labor officer, and then as well as if the workers of the company have a union, you would have to notify the trade unions to be able to assess the amount of benefits packages that each worker is entitled to. And the law actually explicitly sets out a procedure. So with that, you have to follow that procedure to be able to effectively say that you have laid off and you are relinquished all your legal obligations as an employer. If not, you'll be found wanting and your employees can take you up.
Yes. Doc, we are discussing redundancy and what the benefit, what redundancy is, and some of the benefits that an employee is entitled under redundancy and the procedure. Doc, if you could help us with a little more information on that.
I think she's gone off.
Okay, I think Doc is having an issue with her internet. So, all things being equal, if someone is leaving the employment and you are restructuring, it means that the employer will go to the chief labor officer, they'll go to the association if there's one, and then they will all decide on how to go about it, how to lay people off. And some of the questions people ask me is, so if my employer is telling me, Anita, I'm restructuring, so, and I don't have money. I'm restructuring and laying off because I don't have money. Now you're telling me to make all these payments to these people. How am I going to make? Then the company might as well collapse. What will you tell such an employer?
In such situations, I would say then, I mean, even though it would not be the most appropriate, you can go to your contract of employment and then terminate in accordance with the notice period. That if that would be a more viable
but then
portion.
if you find out that it was
because
of redundancy, then
the liability, yes, then there will be some sort of liability.
Yes.
Especially if it's en masse.
Yes.
If it's probably 2 or 3
Are you trying to tell the employer how to go about it illegally?
You could also arrange payments. Maybe if they are off payment plan, they are off your payroll, you get into an agreement with them.
Yeah. Yes.
So
that's a very valid way. So it's possible that they might not pay you off once. You understand? You come to an agreement, the structure, and how payment. So now let's look at grievance. In every relationship, there's conflict. And I tell people that if you're in a relationship and there's no conflict, then it's not. Something is missing. Someone is pretending. Someone is lying. You understand? When we talk about conflicts, we're not talking about fight in Tokwa. Conflict is disagreement. You understand? And in every relationship, there is that disagreement. So if there's a disagreement between the employer and the employee, how do we go about it? How do we look at it?
There should be that communication between the two parties coming together to resolve their grievances. As in, each party should put on the table what is the challenge and see ways to how they can provide solutions to their troubles or problems that arises from the company. I think that's the best way. And most often when it comes, the employer should not be arbitral, because the Constitution also fronts it that you don't give the opportunity to the employee to be heard, and that's not also, it frowns on the natural justice principle. You need to give them the opportunity to also be heard. Let's say you don't take the rule into your hand and you dismiss them without being heard.
Yeah, that's okay. Any other?
The grievance procedure. Internally, I would always say go back to your contract of employment. It's the most important source. So if it doesn't state out the grievance procedure, there should be probably a conditions of service, HR policy, or some sort of collective bargaining agreement that you can rely on, because usually it will tell you the first step and an escalation procedure. So probably you have to report to your supervisor initially, or if it is your supervisor, then you report to the next in command. If you do not get a resolution, you report to a next step. And then there are even instances where if it is supposed to be a disciplinary committee, you are supposed to have a union rep as part of it, so that that person would ensure that the procedure is done in accordance with the terms of the agreement and the worker is not treated unfairly, or that if you are entitled to some sort of legal representation, whatever that is due you that you can use to effectively represent yourself or to make your claim should be due you. So the first point is to look at what your contract of employment says. If there's no grievance procedure, you look at the collective agreement, and then you can use the procedure outlined there. If not, then Act 651 is also there. Yes.
So we'll look at the access. Yes, we can.
And also, some organizations also will issue a query. It's also a form of resolving. So they just want to hear from you. So they issue a query and you respond. And that's also a way.
But one thing I've seen about query and you responding is that some of the contracts or service will tell you that if you receive 2, 3 queries, that is a ground for termination. And so I often tell people that don't wait to be queried. You see, if an employer that it's not into you or your supervisor is not into you, all they will have to do is issue queries. Yes. And so you put yourself in a position where queries are not meted out. And when they are meted out, you respond in a way that ends the discussion and the conversation. So let's say, for example, an issue has arisen, right, in your company. And it's going back and forth. They say you've done something, theft. And in the organization, they'll take you through, right? There'll be a disciplinary, because the whole rule, as Peter said, is that you have to be heard. They can't say you've stolen, Peter, you've stolen money from the account, so leave the institution. It's not done. They have to hear from you. So they'll write to you and you respond, and based on your response, they can make a decision, or there'll be a disciplinary committee where you come. And when you are going, I advise people, take your lawyer. Someone will tell me that if you take your lawyer, it means that you did the thing. Well, if you don't have anything to hide, why do you take a lawyer? But you see, it's better to be seen as guilty than to be declared guilty. So you go with your lawyer, you do all that you are supposed to do, and when they want to terminate it, then they do. But sometimes, when the process is ongoing, depending on your position, they will say step aside, because frankly speaking, the position you feel in, you might tamper with evidence and the whole. So step aside. So what's the whole deal with stepping aside? Are you supposed to be paid? If you're supposed to be paid, how much? The quantum? What goes into that?
So we've noticed that some companies will give you 1/3 of your pay, some will give you half, but it's not stated in the law. So we don't know why people are doing so. If you are asking the person to step aside for investigation purposes, he should be entitled to his full pay.
I think I've seen one of it. Is it the Labour Act says that
there's
the
50%.
50%. Yes, you are entitled.
So a number of the collective agreements would state 50%.
Because it's also
so after the investigations conclude, if you are found guilty, then you are forfeiting the other 50%. But if you are declared innocent, then the other 50% is given to you, and all the other benefits. Yes.
Right. So we are going for the short commercial break. But let me summarize it as this. Yeah, can say. Only obi ye juma, and you automatic say ube only nipan me ye juma febo, and nipan be person obi ye juma febo. Adi ye can say by all means, maybe or no nipan only ye juma no. But per se ubeko for one reason or the other. And now also no chale when you baby fufro into ube per se ubeko. It's allowed. Into ye shano say into many nipa way ejuma ye. Saying be na metimi film and saying be no so betimi film. Ni eka say, ono betimi aka che o say, bra, sister, ejuma na no ya eche, but sisi anem pese me lay off. Pese uja ejuma no. Inti me ma 1 month. All things being equal, documents also eka say your documents be condition of service na contract of employment. Usually no, nyema we ni na say ni be you we di ni awo. But say most often than not now, we are looking at sometimes 1 month, sometimes 2 months, 3 months. By law, they can say 1 month in due notice. I say 1 month, ne film. But 1 month to say for film, I say 1 month salary. Into a baker say, a china me so jay jumano. Such number so Jumane dia, Obama 1 month salary. You are supposed to give the whole employer Obama 1 month salary because 1 month 1 month we no. Edu baby aso nipa no so film no. Otu no so timi ka se me fi adwumanim. Ono so 1 month no. Ono so amasa employer no 1 month na by all means and just employer no. Ono to employer no 1 month. We ka so say obi wo hono ma wewu. Uwa say etwa kambe na owofo ne enkwafo wo. Nti we would do ya and then one of another reason. Obi also am a state of conduct talk we bibi. Ya state say yenye say no akoye. It me terminate employment. Obi so hono ma obeka cho senti why yari bia ejuma no ntimi nto aso. What I say ejuma no ntimi nto aso. Nti wo so ye hwe say ejuma no ntimi abo abetimi ama position foforo bi ebetimi abo say ntimi de na say oko. Na ya discuss so we be a friend redundancy, restructuring of the company. Say company bi wo hono ma nyama nko yesa nti ompese omosesa nyemu no mo yi nkofu ni bi edi ye ka cho se enyi wedi a enyi wedi se oma ohwe o depending on mo contract no ebi wo ho ye mo nyama bebre ebi wo ha ye be ma ebi minimum bi wo kra ye mo 6 months salary obi wo ho no ma ebi wo what I say nti se o say enyi wedi a entimi nyi edisa ina eso ye ka say unfair termination yentimi ka say employer sorry ya menu nye dwuma biem ko because wa wo ba obi wo ho ba bi wo ho no moko wo ye ne aka che ne say wo wi amemba biem unfair termination ultimate take wo employer no on yetimi prove say because of the pregnancy na ye betimi ne de akoko ze benye ska kakra fine obi so ho no ma o ka say we ye tribe ya na say me send ne med down man da nyama bebre ho no ma obi enti ogina so eyiwedi. Se nipa ne yesa ye friend unfair termination it me gi nipa no ho skaka cry betimi abo na last no ye discuss grievance edu baby you know only obi wo relationship mu a ntokwa kakra be ba we see the be no obi relationship na wechu kakra mba na so be pretend I say but always there be disagreement in here move in different places nti ko ejuma ni na no obi ejuma na disagreement be na say wakoye bibia ontimi nka say hey because we know I know wako wi ade and I say wako wi ade nti ko wonti nya sa e so the procedures bito e je sa otie wanu masem mate so wako wi ade ampa so wi a ebi mu ye committee no ma invite
Hope Channel is my favorite Christian channel.
Yeah, ka asem na wo hu asem ne baby eko. O lawyer ho beboa. Ba sure what you say. Nti uni lawyer kwa na o lawyer friend na o kwa person o kwakra please the advice. Answer wako. Nko amen kosa because emboa. Ini asa aka so say edu e bia wo ye li baby o ho no mo na ya ka che say oh all things been call me passion baby. Ade a wo ye no position na wo hwemu no ntino yentimi emma wo enwo adwuma ma bra ye investigations nti kotnefi o contract me che wade awon however se contract and nisa contract ma law ne ma say e so more 50% or salary 50% sa and so we case no omo we case no na udi bema wanye hwe a sa 50% na ye tie nia no edusi ka be ma no benefit ni yan de what dey be ma now the pay dey say no and say oko 50% ready no no aye so let's at least you are 50% edikakra so now let's look at your advice. So let's say for example you someone comes to you and tells you I have an issue with my employer. What comes to mind as a lawyer, and what advice do you usually give?
For me, the first I ask is, especially if you are still in the employ, if you are yet to be terminated, it's a different process. But if you are still in the employ and you are yet to meet, probably you've been issued a query and you want to know how to go about responding to the query, that's, I would advise you to refer to your contract of employment and your conditions of service, and to be sure that you have whatever response you give, you have some sort of evidence backing it. It is in accordance with certain rules and procedure. And if you are out of the employer and you have a grievance with your employer, I would advise you to also look at your contract of employment or your conditions of service or the collective bargaining agreement on how, especially for wrongful termination, the procedure to follow, or the benefits that you are entitled to, and how to acquire such benefits. Yes, that's my...
Okay, so it's also best to look at the offense as well.
Okay.
So looking at the terms of engagement, to look at the offense that the employee has engaged in, or the grounds on which he or she has been, the employment has been terminated. So look at those ones. What are the benefits? How can the person be restituted into the organization? So look at all those things, all those factors before you give an advice to the person. Okay. So the other modes, actually, you can also address this, that you could also ask the person to lodge a complaint with the National Labour Commission so that the matter can also be addressed. They could also take up the matter. But in that instance, if you use the Labour Commission, it is a Labour Commission with that institution, and you become an interested party. If the Labour Commission is not ready to execute the judgment, you cannot take it up. We have a similar matter where the interested party, who is affected party, cannot execute it because it is against the government. And you know the National Labour Commission also works for the government. If they say,
they'll beat you for saying that because they don't work for the government. They'll tell you that they are the mediators between the government.
Perfect, but it's also a government organization.
It's not a government organization. They were here last 3-4 weeks, yes, and they'll tell you yes.
So they are not paid from the consolidated fund?
They are an independent body,
yes,
mandated to be the, in quotes, the mediator, the arbitrator.
Are they not paid from the consolidated fund?
A lot of people are paid from the consolidated, but that doesn't make them.
So the constitution, when you are looking for a public service,
yes,
are you saying any institution that's paid from the consolidated fund?
We are not saying that, but if you say they work for the government, that's a different ball game altogether. They don't work for them.
They have their assigned duties. I beg to differ with you on that. Okay. I think they have their
so it's difficult sometimes. If it's difficult to execute the judgment when you take that tangent, so you have to look at the modes. If you have a lawyer, legal aid, so there are other various modes of addressing all these issues.
Yes, they are. So let us say, for example, is it Esther? Esther has sent me a long one, but I was trying to read it, but what she was saying in a nutshell is the fact that it seems as if the employer always has the upper hand. The employer lays people off when they want, as they want. They terminate. Sometimes they'll not let you know that sometimes they give you one, they'll tell you don't come the next day. But all that we've said so far, we've told you that the employer cannot do that. Right, Esther? I think we've said that the employer cannot do that. So if I should say give your final words to the employer.
Can I address Esther's issues as well?
Sure.
You see, employment relationship, it is not a contract of servitude, and it's not a contract for life. Each party has the right to terminate the contract. And so once you are working, you don't see your employee as a servant. These are equal parties to the contract. And you to the employee, the contract is not for life, that you are going to work for life. No.
But at least when you are laying me off, I want to know you are laying me off for the good reasons. And I want you to lay me off per law. And if I'm also laying you off, I should be able to lay you off per the law.
The act says that everybody has the free will to terminate the contract. Everybody is free to terminate the contract.
But at least you should have a good reason. Now the courts are moving in that direction. I'm loving it because you see, if, let's say, you are sexually harassing me, and then you tell me that I'm terminating your contract, there's 1 month notice. There is a reason why so it is not mutual. There's a reason behind it, and I should be able to take you up on it. And that is where the court is leading us now, and that is why I'm loving it, because you have the right to terminate my appointment, give me 1 month notice. However, if there is a reason, I believe, and I can prove that's why I'm being laid off, that's unfair termination. And the person should be able to take it.
It all boils down to
Yes.
proof. Once you think contrary to the reason that's been given, then you can go ahead and prosecute it. It's just that, unfortunately, when you are out of the service or out of the employer, of your employer, it's difficult to have access to a number of documents. And so, like you were saying, the grievance procedure, if you decide to go to the Labour Commission route, it's more of a mediation, arbitration, or negotiation settlement mode. So it's not very, how to say, adversarial.
Yeah.
So you cannot enforce or compel the employer to submit certain evidence. However, if you decide to go to the court route, then you can take advantage of the discoveries to ensure that your employer furnishes you with all the needed documents that will enable you prove your case. Because most often than not, you realize that with disciplinary committee hearings, the employee who is dismissed does not even get a copy of the memo or the minutes of the meeting. You are just notified that at a meeting on this date, you were found guilty, and then
they submit the report.
Yes, and they submit. So, because you will need all those things to prove your case. So if you are, the route you choose is dependent on the nature. It's on a case by case.
Yeah. Coming back to the point where someone, when the NLC was here, the National Labour Commission was here, someone just sent a message and told me, Anita, they are toothless bulldog. The director herself was here, Human Resources was here. And I asked, someone told me, it's not true. And how she gave us the reason. Please, you have to go and watch that video, okay? She really gave us the reasons why she's like. So, then your final words to the employer and to the employee.
To the employer, treat your employees fairly. Ensure that before you terminate an employment contract, you are going per the contract terms and not contrary to it. To avoid any liabilities in future for yourself, and any stress that would come or extra resources wasted on prosecuting the matter in court or at the Labour Commission, whichever route is taken. And for an employee, always ensure that you keep documents of or records of everything that happens during your service period. Whatever query that is given you, whatever disciplinary committee you face, you should always insist on having copies of those records, just in case in future you need to use that to enforce your rights. Yes.
So to add up to what my sister just said, in keeping records, for some organizations, when you join, you'll be given a corporate mail, and that's where they will channel all your queries and disputes issues to you. As soon as you are asked to exit, you don't have access to it, and you can't have access to any of these documents anymore. So it will be best that as you are in the company, and you are using a corporate mail, you channel those, you forward those messages to your private mail, so that at the time that you want to take them up, you can use those ones as well. Okay. So that's my advice to the general public. And for organizations, please, as you dismiss people unfairly, the image of your organization is being tarnished, because you put up in dailies that people can join, and when they join, they have the opportunity to grow. But if they get to hear that you dismiss them unfairly, that picture of your organization is being tarnished.
Okay, thank you so much. Thank you so much. So, this is the last episode. It's been one hell of an episode, right? We've had all the big guns here, and they've really educated us on what to do in respect to the relationship. All I will say as my final words for this season is that this relationship it's a good one. The employer gets work done, gets money to feed his family or her family. The employer does the same. Until we are helping each other. So if one is going to be a parasite, this relationship will not work. So all that we've said this season is the fact that an employer-employee relationship is a good relationship which should be maintained with clear mind, clear heads, and fairness. all documents entitled, the employee is entitled to employer, give it to the employee. Employee, when you're working, work well and diligently, as if you are working for God. And that's what the Bible says. So when you are leaving, you leave with a clear mind. You go to the next organization. You do the best. You move to the next. You move to the next. And you settle where you want to settle. I don't have a problem with you leaving organizations. As 2 weeks our previous panelist said, you can leave. But do the best you can so that when you are leaving with a clear mind. And you're going to do bigger things out there. So again, that's season 4, right? Season 4 has ended. And God willing, we should be back around September, October. We are looking at that time for season 5. And season 5, we'll be looking at the business proper, you see. We're looking at the auditing, procurement, and everything that has to do with the business. So if you're an employer, season 5 is for you. If you're an employee and you want to be an employer one day, season 5 is for you. So my vote of thanks, you know it's important. First, we thank God. Shall I? Always coming here, contacting people, all the panelists who have been here. We are grateful, we are thankful. Our dedicated staff and experienced team, shall I, sometimes you can see they are tired, you understand? But they are doing the work because we want to educate the general public. Atanya, hey, sign language. Sometimes I look at her, I look at him, I go like, what is he doing? I think it's many years of experience. Atanya Meche, so grateful to be part of this team. We are grateful to you. So our sponsors for this season, we had Mamel's Creation, Rose on 0541 809393. You had Samuela Ella on 0243018508. Still, please call them if you need materials or you want someone to sew your dress for you. These are the 2 women you need to talk to. And please, you call my name, Nationwide Delivery. You just say Anita Delight said I should contact you and you get a discount. We need sponsors. So please, if you're a business person out there, an entity, an individual, you want to support us, please get in touch with us on 05. We are 0559680066. So that's season 5. We have a lot of sponsors and lots of fun. So as I say, most importantly, my cherished viewers, your contribution. Hey, Anita, you did this, and you were wearing this, and they said that, and hey, you are the best producers ever. Thank you so much. And if you ever want to watch any of our episodes from season 1 to this season, go to Facebook, The Law Chamber, and then you see our way there. So until September, October, please be safe out there. And please, tell that friend to tell that friend to tell that friend that God is coming. Evangelism. Adieu.